counsel, whether or not you, in effect, served as as somebody that was intertwined with the other business with Regional Trustee Services.
No, Your Honor. The declaration of Mr. Solsing lays out specifically that we are, Robinson Tate and Regional are two separate entities. We do not share ownership. We do not share physical office location. We do not share officers. And Robinson Tate has no control over the actions of Regional or any of our other clients. We have advisory capacity. And I think actually that Ms. Dow comes to this conclusion at the end of her argument, which is that Mr. Solsing can advise his client that maybe a particular thing that they do is not best practice, but he can't get them to change the practice. That is their decision. And that is why the liability, if any, lies with the principal and not the agent in this matter. And that is why the McCassin case came out the way it did, and that's why we say that there is no liability. I just want to address a few more things if Your Honor will permit me the time. The first is that under CR 56, you can't rely on her allegations in the complaint any longer. We're through that part of the proceedings here. And with respect to, I think the core of the issue here, whether we are in essence the trustee because of the intertwinement, I don't think that stands up to Mr. Solsing's declaration. I don't even think it stands up to his deposition testimony in which he talks about the relationship between the two companies. Yes, our clients are free to give referrals to other clients, to us. I don't know of any other lawyer who at least doesn't hope to operate in that fashion, doesn't hope to get referrals from their other clients. But to suggest that this is some incipient evil that must be ferreted out and addressed in the CPA claims is frankly outside of the bounds of reason. In fact, if you look at the Lucero case, which is the one that they gave you as, I think it was
J.
Attachment J to their opposition, they address the relationship, the court addresses the relationship between RCO, Ralph Crabtree Olson, their business entity, and the Northwest Trustee Services. And the court says, although there is clearly a relationship between Northwest Trustee Services and RCO, they are two separate legal entities, each of which can be held responsible for its own wrongdoing. Plaintiff has not addressed the standard for piercing the corporate veil, has not alleged or provided evidence of inadequate capitalization or failure to observe the legal requirements for a corporation, and has not explained how further dissection of a particular deposition transcript will help her show that the separateness of the entities should be disregarded. Similarly, Mr. Romero doesn't do any of those things either.
What page were you reading from?
Excuse me, Your Honor. That is, well, it's page 5 of the Lexis printout. The header there is one, identity of the parties.
Yes.
So the court here, Judge Lasnik here is going through the various theories. That A, that they're essentially the same entity. He discards that theory. B, that there's a respondeat superior argument. He dismisses that out of hand because plaintiff doesn't make any attempt to show that in that case RCO has violated the Deed of Trust Act, and he or she doesn't, Mr. Romero doesn't either. But the third there on page 5 is the theory of aiding and abetting, and that really gets to the core of the matter here. And with respect, Judge Lasnik does not cite to McCassin v. State. He doesn't consider that line of cases that McCassin brings in from the state of Minnesota and other states that stand for the proposition that a lawyer must be free to give advice to his client unfettered by concern for a third party. Because to be concerned for that, in terms of a negligence theory or a breach of a statutory duty theory, short of course, malice and fraud, that the lawyer must be unconcerned with those interests, because for it to be otherwise would taint his or her ability to give advice to his client. Your Honor, I also want to address, she points out that her client, in addition to, because the CPA, in her words, doesn't confer an actual specific duty to her client, a telling admission, but she does state that it can be used to vindicate public rights. So in our motion for summary judgment, memorandum in support, page 12, I addressed the Hangman Ridge case. This is at 105 Win second, or Wash second at 790 and 791, where the court says the normal course of action, as we understand in the CPA, is if the Attorney General's office wants to come after a corporation for unfair, unsound, or deceptive business practices, the Attorney General is certainly free to do that. They have standing. But if it's a private action, there are elements that are necessary to be proven. And the Hangman Ridge case says that its factors are: 1, whether the alleged acts were committed in the course of defendant's business; 2, whether the defendant advertised to the public in general; 3, whether the defendant actively solicited this particular plaintiff, indicating potential solicitation of others; and 4, whether plaintiff and defendant have unequal bargaining positions. Now, element 2 and element 3 cannot be satisfied by the showing of plaintiff in this matter. The advertisement that plaintiff has produced, that that Mr. Romero is indicating is a joint venture indicator, a joint advertisement between Regional and Robinson Tate. In her argument, Ms. Dow concedes that that's not an advertisement to the general public. It is an advertisement to a niche area of the mortgage lending industry, i.e. those portions of the mortgage lending industry that deal with defaults and post-default activities. Second, there is absolutely no evidence in this matter that Robinson Tate, or regional trustee for that matter, but Robinson Tate actively solicited Mr. Romero. And I think that the theory underlying that third element is, again, the same theories that we're touching on within the other cases, and it is of a piece, which is that if there is no duty between Robinson Tate,
my law license, that doesn't mean that I render some legal services because I show up and perform a particular services. So I would disagree with that particular analysis, Your Honor. And in terms of just housekeeping matter, Your Honor, we also brought a motion to amend, and I don't know if the court realized that. We have piggybacked it for this day as well, and filed the motion to amend.
That was mentioned also in the respondent's materials, I believe, and I think you indicated, counsel, that that didn't necessarily change your analysis.
no, Your Honor. This motion for summary judgment is based on the amended complaint as is pled and the evidence in the case. It is our position that the
when I asked the question about a case under state law, which would have held a lawyer responsible for advising a client to an individual, I didn't get any particular reference from the plaintiff, and I think the reference to the Lucero case is interesting, but the fact that I looked under duties, it did not appear to suggest that there was a duty on the part of a lawyer representing the bank to do a certain thing. And it does indicate that the trustee has a duty of good faith to the borrower, but it doesn't speak to what the lawyer for the trustee has to do. I do think that there is a duty issue that has to be, even if it were left to stand alone, would not I would be in support of the motion to dismiss on summary judgment. But more importantly, the act does not empower, by any of the cases that I have seen, a situation where does not empower this plaintiff to bring a case against this law firm, which appears from all indications to be acting as a law firm. Now, there is argument that they did more, but in a motion for summary judgment, the responsive party cannot stand on argument. They have to actually show something firm and direct to address the declarations and the other items of record. The declaration of record from the law firm indicates that it is a separate entity, that it is serves in an advisory capacity. I do not believe that the quote-unquote joint advertising changes that. I do not believe that the number of referrals makes a difference, and that appearance of mediation doesn't change the essence of the two individual corporations either. So, if then this law firm was acting in its law firm capacity, which is what the record shows, there would be no genuine issue of material fact which would hold the law firm liable as against as opposed to Everbank or Regional Trustee Services.